Hi, my name is Heidi, been there too, and welcome to a partnership meeting organized by Friends of Buckingham and the Virginia Community Rights Network. And we have a number of things to introduce you to. The bathrooms, let's just go through some housekeeping first. There's bathrooms in the back on either side of the entry hallway. And there'll be water and ice cream and brownies down below in the basement afterwards. So, and fellowship. So please stay for that. And I think we can get started, but I think we need a prayer from Mr. John Laurie. Do you want me to bring the mic to you, or you want to come up here? Yeah, you want me to come there? Okay. Can you follow me back there? Great. Oh, I guess I want to say a few more things. Thank you all for coming. Also, thank you for Arjaban here for doing all the tech work, and Hanuman for facilitating that and making it happen. It's a big deal. And Mr. John Laurie is one of the deacons of Union Road Baptist Church.
Heavenly Father, in Jesus' name, we thank you for the letter. We thank you for blessing us, loving us, keeping us, protecting us. And you ask, Heavenly Father, to continue blessing upon us throughout this program. We ask that you will guide us, keep us, that all that we do, that it will be done easily and all. And we thank you. In the precious name of Jesus. Yes.
Amen. Amen.
Thank you.
Yes.
We spent many of time here in this church fighting the Atlantic Coast Pipeline, thanks to Union Grove Baptist Church opening their doors to us. And previous to that, it was Union Hill Church, which is kind of down the road and around the corner. All
A
right.
little more clearly, please, Heidi.
Okay, so thank you. Arjaban said, when you hold the mic, you got to hold it like this. When you hold it like this, you don't hear it, right? Okay, so like a so. All right, so the good news is that there is widespread agreement that we don't want an industrial gold mine or a metallic mine in Buckingham County. And the supervisors are included in that agreement. The supervisors, the Board of Supervisors, can be quoted for saying recently something definitely needs to be put in place. That said, Jordan Miles, who is the Naysville supervisor, also said, quote, I would like to see the state gold mining study done because the General Assembly may say, you know what, we're gonna go ahead and ban it statewide. But we can't count on this. If the state moves to ban this, it would be our efforts that would make it happen. I'm talking about you and me. The state is not going to do it on its own. So that's a big lift. What we need to, so let's see. What we need to agree on is how to protect ourselves. We have looked closely at the last supervisor meeting, which provided some questions to dive into as to why a rights-based ordinance has been written. We are fortunate to have Ben Price with us here today. He'll be with us shortly on Zoom. And let's see. He helped us to write the Buckingham County Toxic Trespass Ordinance, and has been working with communities across the country since 2006. He helped Halifax write their community bill of rights, an ordinance to protect from chemical trespass of uranium mining. So we modeled our ordinance after their rights-based ordinance. And Halifax is just down south of here. They're also in the gold pyrite belt. That spans essentially from Halifax to Fairfax in Virginia, and really from Georgia to Newfoundland. So let's see. We've organized 3 major questions for Ben based on the recent meetings with the Board of Supervisors. And we'll pose those questions for Ben for him to discuss. We'll take questions from you before moving on to the next question. So we'll have about 15 minutes per topic. And so we'll see how it goes. And then at the end, so that's about 45 minutes just to kind of give you a time frame. And at the end of that, we'll see where we are, and we'll open it up to just general questions. Okay. All right. So the supervisors have tabled the proposed rights-based ordinance. And it seems that it's based on misinformation due to the advice of the county attorney and the county administrator. Supervisor Matthews made the following statement at the last Board of Supervisors meeting. The county cannot adopt anything more stringent than the regulations set by the state.
Can't hear us.
Heidi, we're losing some of the words. It's like muddled.
Okay.
It may be the equipment.
Nope, just remind me to, because you have to hold it up like this. You can hear me now, right?
You
Okay.
want to see Ben.
Yeah, do you want to put that?
Maybe a little more slowly so that we can hear you and understand.
Okay, so we're gonna pause to put Ben on the
You're
screen
asking
here.
him this question.
Yeah. I still have a little background. I haven't quite asked the question yet. Hi, Ben.
We can't hear.
Ben,
you.
please unmute yourself.
All righty. Hello.
Hi. You've been hearing everything I've been saying, right?
Sure.
Okay, good. I have a little bit more before we get to the question, and you can clarify, please, anything that I've said and correct if need be. So the rights-based ordinance is outside the box of allowable regulations that Supervisor Matthews is talking about. It uses rights-based thinking and is actually civil rights law. It asserts our rights not to be poisoned by powerful industry. The ordinance avoids the limitations set upon us by regulatory law, which, multiplied many times over, has led us to the ecological crisis that we are in now. So Ben, our question for you is, would you please explain how this local law can protect us from getting what regulatory law has allowed and permitted for decades, if not centuries? Thanks.
Sure. I'll try to respond directly to the question. And if I'm not clear on something, please let me know. I'll try to explain it further. But first, I think we have to understand what the difference between regulating an industrial mining activity amounts to, and what it means to protect the rights of the members of the community of Buckingham County and their natural ecosystems. And there's a difference, because to regulate means to legalize a certain amount of harm that is known to accompany industrial activities like hard metal mining. And so whatever regulations are in place in any given state, that essentially it defines how much harm can be allowed to the mining activity, how much harm in the way of harming the environment, the water table, the drinking water, the air quality, in fact, the quality of life for the people around the activity, and also the quality of life for the ecosystem, for the other non-human living things. And so when there's a challenge to an ordinance of the sort that's been drafted here, the toxic trespass ordinance, I know that the supervisors are very used to getting advice from the county administrator and the county attorney that have to do with the regulation of certain corporate activities and extractive activities. But that's not what this ordinance is about. This isn't about trying to regulate more strictly than the state does. Although personally, I think that that should be the case, that you should be allowed to regulate more strictly. But your supervisors have been educated and conditioned to believe that Dillon's rule vetoes the ability of them to enact laws to protect the interest of the community in Buckingham County. The fact is that the state does have in place preemptive laws, and what the claim of the county administrator in the memo that's been cited amounts to is to say, well, this ordinance seems to regulate metal extraction, specifically gold ore extraction, in a way that is more strict than what the state does. And because under Dillon's rule, localities like counties and municipalities are preempted, in other words, forbidden from enforcing regulations that are more strict than the state allows, then such an ordinance would be invalid. The problem is that the understanding of what this ordinance is under that memo is incorrect. This is not a regulatory ordinance. It is not put in place, the language does not challenge the state's regulations, and it doesn't go further than those regulations do, because in fact, what we're relying on with this ordinance is powers that the Board of Supervisors do possess. Any local government possesses the authority to enact local law that allows them to engage in the kind of local governing authority and processes that are recognized as authorized by the state. And they include what's called police powers. And when I say police, I don't mean uniformed officers. I'm talking about the ability of a local government to enact laws that protect the health and safety of the community. So maybe sanitation laws, it may be various types of laws, parking, just safety laws for various types of activities at the local level that can be regulated, if you will, that can actually not be regulated, but governed. Decisions can be made locally that have the purpose and the effect of protecting the health, safety, and welfare of the community. So when we look at a law that protects people from being poisoned, and that's what toxic trespass amounts to. Well, the trespass is something that we're familiar with in property law that says that we aren't allowed to enter the property that belongs to someone else, another individual or a corporation, without their permission. We're asserting a similar kind of general broad right, which is that no industry, no extractive industry or corporation gets a pass to trespass on our bloodstreams with toxins that they place into the environment, into the air we breathe, the water we drink, the soil from which our food comes. And so there is no additional regulation being imposed on that industry. There's simply an affirmation that they don't have our authority to poison us, to put things in our bloodstream without our okay, without our saying that we volunteer to be recipients of that. And so this is not a regulatory law. I mean, it really comes right down to that. This is a civil rights law in many ways. It's about protecting the health, safety, and welfare of the community, which of course the Board of Supervisors have absolute authority and power to do so. As a matter of fact, it's part of their sworn duty when they take the oath of office to take care of protecting the health, safety, and welfare of the community. And when they get advice saying that they should not do that, I'm not suggesting that that advice is offered in any kind of nefarious way. I think there's a simple misunderstanding, and that's understandable in itself. It's unusual for local governments to enact laws that actually protect the health, safety, and welfare of the community that then come up against and in conflict with wealthy corporations that insist on their ability to profit by engaging in activities that pose risks to the health, safety, and welfare of the community. Now, I feel like I should pause for maybe some incidental questions and so forth, but there's a lot more to say about this. But let me go ahead and pause here and let me see if there's anything else that folks would like to hear about on that question.
So I have the mic and we have a question from Marie. Is there anybody else that would like to ask a question after Marie?
My thought is that shouldn't this be more inclusive to include chemicals? So not only mining, but, or does, maybe I'm not understanding it properly, but so that, you know, to get to have this passed, I think it should be inclusive for anything that can be a toxic trespass.
Oh, thank you for the question. And I don't disagree with you that it would be great to have laws in place that say that it's illegal to trespass on residents of the county's bodies, their bloodstreams with toxins, involuntary poisoning, essentially. This law was drafted with a particular concern in mind, and that is the opening of an extremely large pit in the ground where toxic chemicals would be used to remove metals from ores, where those chemicals and poisons that would be used in the process of mining for the gold or other metals would, in some, it must be unavoidably really, would enter into the environment, into the air, water, and soil of the county, and that this would have negative effects on the health and safety of the community. And I'm talking about the people in the community, as well as the natural environment on which their health and safety relies. And so, yeah, it's a narrowed down focus on the source of those toxins. But at the same time, this is about, we can see that there's already some difficulty understanding from the county administrator and from the county attorney that this is narrowly focused on protecting the authority of the county to protect the health, safety, and welfare of members of the community. If we were to expand it out and include pretty much any kind of poisoning, you can imagine that the amount of opposition to the proposal would skyrocket, that anyone who uses anything that might be considered to be toxic would be opposed to it if they want to continue doing that, engaging in that activity. And that may include things like spraying your garden with pesticides and so forth. We may all wish that those poisons weren't used, but I think that in real terms, in terms of what can be accomplished with one law, I think we have to decide to focus down a bit. The other thing is that there is generally a legal concept. It's in politics, they call it log rolling, where you put so much into a bill, you can't really say what it's about because it's about so many different things. And the legislature generally requires, especially of local laws, maybe not of themselves, that there not be any log rolling, that there be a single issue, a single question, a single object that the law is intended to address. And in this case, that single concern is the likelihood of toxic poisoning of residents of Buckingham County by the extraction of metals. So that's generally the reason for it being focused down. I hope that answers the question.
I think it's time to move on to the next question. Yeah, and, but we will, I think maybe that's 2 minutes left. There's a quick, answer.
understand you at all.
There's a quick answer to that, to the topic in a way, because we broadened it from gold mining to metallic mining. So we did broaden it. We at the state level, it's gold, it's limited to gold. We wanted it to be all metals.
And you mind, can you hear me, Nikki? Can you hear me? So, one thing that I wanted to add was that we broadened it to include all metallic mining, but we narrowed it to include only metallic mining. So there are 2 types of mining that are very popular in Buckingham right now, right? There's slate and there's kyanite. And we know that there are some problems with kyanite, but we're not going to talk about that. But those are not included for just that purpose, that we didn't want them pushing back against this. We wanted to really focus on the new metallic mining that was coming in. So, and so I think, just to summarize then, this question, can this local law protect us from getting what regulatory law has allowed and permitted for decades? It sounds like what you're saying is yes, it can.
It can, and yet that's up to the Board of Supervisors. And I think that we should focus on their authority to enact this law at some point while we're here together.
So, okay, so we're going to move on to the second question. If nobody else has any other questions about that one, can you hear me all? I'll hold it the right way. Okay, so on, oops. Put a timer on, so we're moving right along here. On the memo to the Board of Supervisors in the packet from the August 8th meeting, that's the last meeting the Board of Supervisors had. They gave us a lot of information and food for thought during that meeting. The town of Halifax ordinance is mentioned. As mentioned before, this was the ordinance that the Buckingham ordinance was modeled after. So the county administrator and the attorney stated in this memo, and I quote, "The authority set forth in the town of Halifax ordinance might be characterized as, in quotes, claim of right, rather than authorized and permitted by the state of Virginia. Virginia is a Dillon state, and localities can pass ordinances only in areas where the General Assembly has been granted clear authority." And later they say, "We cannot recommend that Buckingham County adopt an ordinance based on this claim of right. It would put the county in a difficult position if called upon to defend such an ordinance." So on that basis, that was their recommendation, and we tabled the ordinance. The Board of Supervisors tabled the ordinance. The rights, so this is the comment for you then. The rights-based ordinance for Buckingham County is grounded on claims of pre-existing rights from the US and the Virginia Constitution. And it draws its authority from them. The county attorney and the administrator are looking at Virginia law as the higher authority of law instead of these constitutions. The constitutions are supposed to be fundamental or foundational for Virginia law, and thus the constitutions should be the higher authority, giving us the claim of right. So Ben, would you talk more about claim of right, what that means, a little bit more about Dillon's rule, and why would they need to defend this ordinance? If you can distill that down for us.
Well, on the last question, why would they need to defend an ordinance like this if it were enacted? The simple answer is because the corporations that hope to reap a large profit from engaging in the kind of mining that they want to do would be opposed to anything that was enacted that stopped them from doing it. It doesn't matter what kind of a law it would be. It doesn't matter if it's a local law, a state law, a federal law, or a commandment from God. They're going to want it not to be so because they can't profit in the way they want to if there's such a law in place. Now, the advice of the attorney for the county and of the administrator are looking through a certain lens. They're looking at this ordinance through the lens of what it is that, who it is that they work for and who their client is. In terms of the county attorney, every attorney that takes their oath and is admitted to the bar and practices law understands that their first obligation is to advance the interests of their client and to represent in the best way they can the interest of their client. And so it's really important in this situation for us to discover who their client is. Now, if their client is the people of Buckingham County, we might expect them to be saying something a little different. We might expect them to be saying, well, yeah, it seems like the right not to be poisoned is pretty basic, and you don't really need permission from the state to protect yourself from being poisoned. And so, what would be wrong with doing that with a local law? But that's not what we're hearing. What we're hearing is that it could raise difficulties for the county if such a law were enacted. And the difficulties involve litigation, being sued by the mining corporation for denying them what they think of as their right to extract metals, including gold and other metals, from the ground in Buckingham County. So why do the administrator and why do the county attorney see that that is the larger concern than the poisoning of residents of the county? And back to the who is their client, is that answers the question. Their client is not the residents of the county. They're not paid directly by the residents, they're paid by the municipality. And the municipality is a municipal corporation. It's a public type of government corporation that is established by the state and owned by the state. And so whatever is in the treasury of the county, and it's not exactly a municipality, but in the county treasury is seen as property of the state, and the client of the administrator and of the attorney are the county, which is a subdivision of the state. And so they're looking at this from the point of view of what's to be lost if this ordinance is enacted, and what's to be lost by the state and by the county, not by the people, not by the residents of the community, because that's not who they represent. And so if you're following what I'm saying here, I'm not claiming that the administrator and that the attorney are doing something wrong. They're not. They're doing what they're legally bound to do, and that's to represent the interests of the county, which is a subdivision of the state, owned by the state. They're essentially in many ways. They're standing guard over the state and the county's property and saying whatever might put it at risk should be opposed. On the other hand, we have you, the residents of the county, looking to your board of supervisors who you elected to represent your interest. And when you ask them to protect your health and safety and to enact a law that would actually not prohibit the mining, but would cause the applicant for any permits to engage in mining to give some evidence, prove that somewhere the activity they want to engage in has been done safely without poisoning the community. It's that basic. It's saying, show us. It's a precautionary principle, essentially, saying that the burden of proof should not be on the likely victims of poisoning to say no to the mining. The burden of proof should be on the proposed mining corporation to show that it's possible to engage in the activity they want to engage in without poisoning the community. That's what you would be asking your supervisors to do if you ask them to enact this ordinance. Now, it's important for us to ask who the supervisors' clients are, if you will. Who do they represent? Unlike the attorney and unlike the administrator for the county, they don't necessarily simply represent the interest of the subdivision of the state, the county of Buckingham. They represent the interest and the health, safety, and welfare of the residents, of the people living within the jurisdiction of that state's county. And so they need to understand that if they ask for legal advice from the administrator and from the attorney, that advice will reflect what is in the best interest of the state and its county, but not necessarily in the best interest of the supervisor's constituents, of you, the people of the county. And in cases like this, sometimes those interests clash. And the problem is that if the supervisors only take the advice of representatives of the state and the county, the people will have no representation. They will be denied essentially a Republican form of government at the county level. They will be denied representation of their rights in a controversy of this sort. And that is something that it seems to me that local elected officials, including county supervisors in Virginia, need to become a lot more familiar with, that obeying the recommendations of an attorney who does not represent their constituents is to deny their constituents representation. That is an issue that I think that you all need to consider and address with your elected representatives locally and at the state level for that matter. I hope that helps answer the question.
Could you speak a little bit about claim of right and Dylan's rule that was brought up in that memo as well?
Sure. Well, a claim of right, we're saying that you have a right not to be poisoned. And as I read it, that, it's actually in reference to the Halifax ordinance, which similar to the proposed ordinance for Buckingham, says that the people of the community have a right not to be poisoned, not to have toxins trespass in their bloodstreams, in their bodies, when those toxins have been introduced into the environment, making them vulnerable to poisoning by a profit-making outfit, a corporation that is seeking permits to be allowed to engage in that activity that is going to violate that claimed right, the right not to be poisoned. If Dylan's rule is raised as the reason that supervisors can't enact a law to protect the health and safety of the community, let's translate that into common sense and see what it means. Dillon's rule says that local governments can't enact laws of any sort that the state hasn't given them the authority to enact. That's Dillon's rule, and preemption is based on that legal concept. And they're talking about municipalities and counties not having authority without the state's okay. But the people themselves retain rights that the state can't take away directly or indirectly. It would be in violation of the 14th Amendment of the US Constitution that guarantees that the rights of every citizen is equal, and that there's due process that is owed to every one of us, and that the rights that we retain cannot be legislated away. Now, Dillon's rule, if it is enforced in a way that has the effect of violating the claimed right not to be poisoned, Dillon's rule is being used in an oppressive way, in a tyrannical way. The theory of Dillon's rule goes back to the 1860s. It was an Iowa Supreme Court justice that came up with it as a way to protect the interests of a railroad corporation against a local law that was enacted in Cedar Rapids, Iowa. When we have judges making rulings from the bench that then are adopted and applied to all communities across the US, that says that the interests, privileges, and rights of corporations need to be protected against democratic lawmaking at the local level, then we need to begin questioning whether a thing like a concept like Dillon's rule is actually democratic, or if it's violating rights. And in a case like this, if it is allowed to block a law protecting members of the community from being poisoned, then it is being used not in a democratic way, but in an opposite way. Claimed rights don't have to be claimed according to our Declaration of Independence. We're born with them. They don't come from constitutions. They don't come from the state. They don't come from anybody else. We're born with them equally. And they aren't to be challenged and overturned by legal concepts like Dillon's rule.
Okay, thank you. Question, Marie?
Were our supervisors invited people?
Yeah.
Somebody else,
Marie?
somebody else wanna? Somebody else. You're gonna give it back to Mark.
Thank you. Just suppose the mining company want to come under the
A
property.
little louder, please.
Hold it up.
Just suppose the mining company wants to come under your property and get your gold or mineral. Do you have to have mining rights, mineral rights, to protect yourself from them going under there? Or can they just go under your property and take the minerals without you knowing it?
Well, I can't offer you specific legal advice on that, but there is a property concept called split estate, where people who own the surface, the farm on the surface, for instance, may not own the mineral rights. So the oil or the gold or the whatever it might be, could be just water under the ground. And in that case, there are differences from state to state over how those rights can be exercised. But it has become pretty common and routine for the mineral rights to have precedent over the surface rights. And so farmers have been dismayed here where I am, I'm in Pennsylvania, but many have been dismayed to find that mining is going on underneath them. They know it often enough. For instance, here in Pennsylvania, where coal has been mined for many years. In Western Pennsylvania, southwestern PA, bituminous soft coal is mined right out from under farmlands and homes and so forth. And sometimes what occurs is what's called subsidence, where the ground collapses into the cavities that are created by removing the coal from underground. And the right to do so belongs to the mineral rights holder, the mining company. And there is no right, according to some legal judgments, for the surface owner to stop them from removing that coal, or even from leaving pillars of coal in the ground to make sure the ground does not cave in, does not subside in. It's just, there's such a long history of bad judicial decisions on issues like this. You could read a number of books on it, so I won't get too far down the road in it. But yes, there is a difference between the surface rights and the mineral rights. The mineral rights, I assume, would be for sites where the mining corporation wants to engage in their extractive process. I would assume that they have somehow purchased mineral rights to those grounds.
Thank you. And it does seem, I mean, in my mind, it seems like an ordinance like this would protect that property owner, because a gold mining company has to come to Buckingham County first and get a special use permit in order to mine. And if we had an ordinance like this in place, they had to go through the hoops that were set up by this ordinance, they wouldn't get it. And so we would all be protected. That's how I'm thinking about it. So, okay, any other questions for Ben on this issue? Dylan's ruled, claim of rights, everything's clear? Marie, you did have a question.
If we had to get an attorney, that would cost money. The money would come from the Friends of Buckingham and but my guess is that we have to do some fundraising to pay for an attorney. And should we get an attorney?
Ben has some strong feelings about that question. Why don't you tell them what you feel, Ben?
Well, it's not so much about feelings. Yeah, you have you're in a situation where you're asking your elected supervisors who have taken an oath to fulfill the duties of their elected position, and that includes protecting health, safety, and welfare of the community. If they're getting that, as I said before, if they're getting legal advice that is offered in protection of the interests of the state and the county that it owns, that's not very helpful to you, to the residents of the county, in protecting your right not to be poisoned, not to have toxic trespass occur. Do you need an attorney? Yeah, but you know what? I would like to think that you have representation with your board of supervisors who have the obligation to protect the community and its health and safety, and that those supervisors would enact the ordinance. And if the ordinance is enacted, it's now the responsibility of the county to engage in defending the ordinance in order to defend the interests and rights of the residents of the county. And how would that be done? Well, the county attorney could possibly be directed by the supervisors, who are essentially their boss, the attorney's boss, could be directed, now I need you to defend this ordinance. And that would be where your attorney came from. Or the supervisors could alternately decide that it makes sense to hire an independent attorney that does not actually represent the interests of the county, but represents the supervisors in their capacity as representatives of the community, of the residents. And we've seen that done in the past, where it's not seen as necessarily appropriate to have the county attorney having kind of a conflict of interest, defending an ordinance that the attorney may have expressed opposition to because of the negative effects it might have on the county and the state, and the treasury of the county and the state. To be clear, the supervisors in enacting a rights-based ordinance and then defending it against legal challenges by mining corporations. Pardon me, I'm sorry, my dog is. Sorry about that. Little noise from the puppy here, but so the funds that are there that have been collected from you, the taxpayers, over the years, certainly they're there and needed to be used for infrastructure, for various things, the daily running of the county. But when it comes to a special situation where the health and safety of the community is at risk, it certainly would make sense for the supervisors to decide that funding the legal protection and defense of the ordinance and your rights would be a proper use of public funds. That may not be seen in the same light by the county administrator and by the county attorney. And again, not because they're evil people, but because they have a different client, because their client is not you, is not your interest, is not your health and safety. It is the county's financial interest, and not having to spend those public funds to defend the ordinance in litigation. So there's kind of a battle going on over various interests here. And what I like to suggest is that if you in the community feel that your rights, and yes, it's a claim of right, you're claiming the right not to be poisoned, and you're claiming the right to have your local government, your county government, protect that right without any special permission from the state, because that's their job. And I think probably should just leave it there.
Okay, so we'll come back to you, Nikki. But just to finish up, what we've been thinking about is, and I think Maggie's not even here, and at the public comments last month, she said, bring it on, bring it on. And I think what we're thinking about is, should the Board of Supervisors invest now in our public health or safety, or pay later for a Superfund site that's the result of a gold mine? Like, that's kind of the choice that we're looking at.
And they won't be able to afford that. I
And we won't be
guarantee.
able to afford that. So we're going to move on to question number 3. On
All right, well, again.
I have a question.
we're going to have the questions at the end.
Yeah, I'll hold your
Questions at the
question.
end.
Hold that thought. So, before I get to the question, a little background. The administrator and attorney, you can hear what I'm saying? Are we good? We good? Yeah, okay. Okay, the administrator and attorney go on to say Virginia is only delegated a very limited role to local government in the mining area. So if we adopt any ordinance, it will have to parallel the state's content and cannot be any more stringent than the state's regulations. The state does not have a prohibition against metal mining, thus it seems a little benefit to adopt a parallel ordinance. So again, that's what the administrator and attorney are saying. We see that the ordinance puts up a substantial roadblock to any invading, and that's what it would be, metallic mine. And so we see great benefit to adopting it now and put little trust in the state to ban or effectively stop metallic mining. So the question is, can the state, there it is, can the state really protect us from the harms of toxic trespass? Is it a good idea to wait for the state study to be complete? Could the county really be sued for denying a permit to mine gold? And that gets into loss of future profits, which I don't know if you quite used those words before, Ben, but that was pretty shocking to me the first time I heard it. Take it away, Ben.
Well, the question and the comments from the county administrator and attorney reiterate their view that this ordinance regulates mining, and it doesn't. This ordinance is about protecting the rights of members of the community. And now in that statement, they mentioned that the state does not allow for local regulation of these industries, and that the state doesn't have any prohibition on gold mining. But I bet they do have a prohibition on introducing toxins into people's water, poisoning people. I'll bet there are laws about that. Matter of fact, I know that under the so-called Patriot Act, and after September 11th, 2001, and concerns about terrorism threats domestically and so forth, that laws were passed to make it very clear that it would be illegal for someone to put toxins into our drinking water supplies, into our air to poison us, and into our food. There are laws on the books, but the problem is you can have all the laws you want, but if they're not enforced and if they're not interpreted correctly, then what good are they? The fact is that Dillon's rule and state preemption against local regulation of mining, that those laws and rules are being misinterpreted as applying to our right to protect ourselves against being poisoned. And we need to, we can't just move on from that confusion, from that misunderstanding of what this law is. It has to be made very clear that this is not in any way competing with the state when it comes to how to regulate mining activities. This isn't competing with the state at all unless the state decides that we don't have a right to say no to being poisoned. And if the state says that, then we should have a lot more to say to the state. We should have plenty to say. Like, who are you to tell us we have to sit on our hands and allow ourselves and our children and future generations to be poisoned and our quality of life destroyed? And if you really have to get down to property interests, our property value is destroyed too on top of that. But there are things that don't have monetary value, and our rights, for instance, the right not to have toxins trespass in our bodies, not to be purposefully introduced into our environment for the profit of a few at the expense of many. This is a matter of justice. It's a matter of environmental justice. It's a matter of democratic rights, the right to make law, to protect fundamental rights. They're at the heart of what we're told in our history classes, in our civics classes, those that still, schools that still have them, that Americans have a right, a matter of fact, a duty to preserve the rights that we hold so that they're not lost for future generations. This isn't an ordinance that's in conflict with the state's limitations on local regulation of mining activities. This is, well, at least it's a misconstruing, a misunderstanding of what the ordinance is by the administrator and the attorney. And I know that it probably causes them some stress to have to think about it in the terms that I'm suggesting, because to do so takes them out of the realm of representing the best interests of the county and the state in opposition to the best interests of the people. But that's what we need them to do. And if they won't do it, we definitely need the county supervisors to understand that they have a different responsibility than do the administrator and the attorney. Their responsibility is to you. The attorney and the administrator's responsibility is to their client, and that is that non-human entity called the County of Buckingham.
Ben, could you maybe explain a little bit more about, it's our second question, about could the county really be sued and how that could work? Because they could get sued by we the people for not protecting us, but they could also get sued by the corporations.
Yes, yes. If the ordinance is enacted, the county can absolutely be sued. Matter of fact, anybody can be sued by anybody for anything. That doesn't mean that whoever sues wins. It's just a simple matter of fact that you can sue anybody for anything. But in this case, there's a real irony involved that a mining corp, and the thing is, this isn't an unusual thing. This is not some extreme example I'm going to use. It's happening right now in hundreds and hundreds of municipalities every day, that attorneys representing corporations, and when I say corporations, I mean corporate property. It's simply wealth held in common by investors. It's not a person, even though the Supreme Court has been talking about corporations being persons for a long time. And as persons, as legal persons, corporations are seen by the courts, not by me, not by anybody with common sense, but seen by the courts as having Bill of Rights protections as though they were human beings. So what happens when the attorneys for the corporation show up at the Board of Supervisors meetings and say, if you pass this ordinance, we're going to sue you for violating the civil rights of the corporate person? What does that mean? It means that they're claiming that if the ordinance is enacted, it will violate the civil rights of corporate property, including, for instance, the Fifth Amendment right, and the Fifth Amendment of the Constitution is in the Bill of Rights. And it has three main provisions in it, but one of them is called the Takings Clause. The Takings Clause says that government can't take private property for a public use without just compensation. And if we translate that into kind of modern ordinary usage, it means that no government, including the county, the state, the federal government, no government can take private property in order to serve some public interest without just compensation, without paying the person that they take the property from for their property. And so the corporate lawyers are going to say, if you pass the ordinance, we'll sue for a violation of our Fifth Amendment rights under the Takings Clause. And that means that the money that we would have made extracting the gold from the ground in Buckingham, we won't be able to do that because of your ordinance that requires us to prove that we can do it safely without poisoning people. And of course, we can't do that. So that would cause us not to mine. And then we would lose all that profit. And we have a right to that profit. That's our future profits, and it is property. And that's the government, the county, taking our property, our future profits, and you haven't given us anything in exchange. Now, if you want, you can just give us the billions of dollars that we would make from extracting the gold, and we won't extract it. In other words, pay us billions of dollars not to destroy your community and poison it, and we'll go away. Maybe. That's the arguments that's one of the arguments that would be made. There are others too. They'll also argue that as your administrator and county attorney are arguing, that the state preempts the county from regulating their mining activities. And back again to my answer to that, it's not a regulation on their activities. It's a protection of the rights of the people. We need to know that we can demonstrate this can be done safely and without poisoning the community. If the county is saying, the county administrator and the attorney are saying, well, we can't make them do that. That would be violating their rights, their free speech rights. Oh no, now it's a First Amendment right. We can't violate their right and make them tell us something they don't want to tell us. What's lost in all of this, these arguments about the Fifth Amendment of the corporate property being violated and the First Amendment of the corporate property being violated, is the right of the people not to be poisoned being violated. And that really doesn't carry any weight. That doesn't carry any weight, apparently, in the eyes of the attorney and the administrator, but it should. And it needs to carry weight in the eyes of the supervisors who represent you, who represent the community, and have a duty, an absolute duty, to protect the health, safety, and welfare of the community. And if they won't do it, I don't know. I've been involved in communities where the elected officials have said, we won't do it. We won't do it because the municipality or the county might be sued. In one particular case, the proponents for a local ordinance to protect the community against poisoning insisted that their elected officials who refused to represent the rights of the people step down, that they resign because they refused to fulfill the obligations of their oath of office. That's really how important it is that your supervisors take up this and follow through on their obligations to the county and advise their attorney that although they thank him for his legal advice in protecting and shielding the county from litigation, what he really needed was advice on how to protect the rights of the people from poisoning. If we expect the state to step in and enact a ban on gold mining in Virginia, I think that's an expectation that has been shown to be unlikely, considering that at the state level, there's still also a misunderstanding that local communities aren't so much concerned about regulating metal mining. They're more concerned about protecting their health and safety when that activity occurs. There doesn't seem to be any admission of the stance and the concerns of the community at the state, the federal, or the county level at this point. And that's what needs to change. Is it going to change at the state level in the legislature anytime soon? Not very likely. You be the judge. This is your community, and you'll have to decide whether you think, as the sovereign people of Virginia, that you need to instruct your elected officials to represent your interests. That is something that's really on the shoulders of the community. to take that up and make that your cause, in my opinion.
Thank you, Ben. Yeah, and maybe we should also make it clear that another ordinance, a regulatory ordinance, wouldn't work. It's like we've been backed into a corner over the centuries, literally, and this is the genius that was created by the ecological crisis that we're in. Thanks to the good people that Ben is involved with, called the Community Environmental Legal Defense Fund. So again, there are over 200 communities that have boldly passed a Bill of Rights, a community Bill of Rights, similar, different issues, but similar issues. So we have another, maybe about 10 minutes for some open questions, and I see Maggie has one, Mukti, Hanuman, and Maggie. So, and who comes first?
Mukti, who won the last time.
Mukti? Okay.
Ben, thank you for the clarity. It's excellent. My question is about avenues of jurisprudence. I have no confidence in the government of this county. We're really burned. We went through it through Dominion, pipeline system. But the good that came out of the bad is we have gained national status here because of the compressor station. And we should use these resources. Also, we have tremendous resources coming out of Charlottesville. So my question is, and maybe we have to follow up on this in the future, if we have to go the route of litigation as the people, by the people, where we will prevail and not the corporatocracy, do we go as we have in the past with environmental justice jurisprudence or strictly civil rights? Because when we're talking about civil rights, it's exclusively the laws of civility that are on the books or not. And if we get very sharp in our future civil rights attorneys, preferably conservatives politically, to come in and say the people prevail. Plus, we have a great deal of support, of course, for the surrounding counties who would be directly impacted. Thank you.
Thanks. I really can't offer you specific legal advice on which avenue to take. And actually that might, I think that you could make arguments one way or the other, or maybe you do all of it, because it is a question of environmental justice as well as a question of civil rights. I share your lack of faith in the judicial system or from the county, I don't mean just Buckingham, but in municipal and county governments, to take a stand on behalf of the residents that they ostensibly represent. They've been conditioned through long habit of simple obedience from top-down government to sit on their hands and allow bad things to happen in communities for years and years. The accumulated effects are doing, extreme and irreversible damage to our ecosystem, and it's been incremental, but much of the damage has happened in the past 100 years maybe. We could be wiser, but we're not. We could make wiser decisions. And those, I think, would be, those better decisions would be made if the communities of people directly impacted by industrial activities and extraction actually had the last say. If they were the ones who were seen as the experts when it comes to the quality of life in a given community. And instead of having some requirement for a scientific study to be done, an environmental impact study to be done, those experts are, they're well educated on a very narrow field of study, but the people living within a local community know a lot more than anyone else does about what it's like to live there, what the quality of life is, and what things impact it in a positive or in a negative way. So I guess I'm trying to say that how we make the case, how we make the arguments, it's going to require some real changes in thinking and how law is used. Because if we continue simply to go along with the regulatory process, which is all about regulating the rate of harm, the rate of destruction of the natural environment, and regulating the rate of destruction may slow it down if the regulations are stronger, and will speed it up if they're made weaker. But in the end, regulating the rate of destruction guarantees the end game is total destruction. That's a mindless, idiotic sense of the logic of what we should be doing to protect the health and safety of our communities, including their natural environments. And so, environmental justice, yep. Civil rights, yep. The civil rights movement that was mounted to end racial segregation, apartheid in the US, they didn't meet with immediate success in the courts because all the laws that were on the books said that it's perfectly legal, it's perfectly constitutional to discriminate based on race. As a matter of fact, it was constitutional for people to own other people until 1865. So let's stop asking, is it legal? And begin asking, is it just? And does it uphold the rights of people who create government to protect those rights? We don't create governments to violate rights or to decide who gets them and who doesn't.
That's burning. Okay. We got to kind of wrap it up, but we have, if we can have a couple more short questions answered. Here's Maggie's nodding.
I think my question is rather short, and I understand what you were saying with the different responsibilities of the board versus the county administrator and the attorney. But if you say, okay, the county administrator and the attorney are supposed to represent the county, could they insist from the gold mine that they put up hundreds of millions of dollars or whatever the number is up front for the ultimate cleanup site that is going to be required? I mean, I'm just curious about that.
Well, I'm not sure if they could or they couldn't. The state might say, well, that's a regulation that we have not allowed the county to impose, number one. Number two, to have a bond of that sort, the presumption is harm's going to be done and we're going to need the money to help try to clean it up. We know that we won't be able to really clean it up. We'll just do a cosmetic job of it because they don't have enough money to really clean it up. I mean, that's essentially, you flip the statement around and it's saying what we have right now, unspoiled, where they propose to put in a gold mine, that you couldn't afford to buy that unspoiled land, that unspoiled ecosystem. We don't have enough money. We couldn't mint enough money to buy that. Why then are we going to issue permits that allow its destruction?
Thank you, Ben. A lot of clarity today. I would say regarding that I think it's like the prove it first. You give them such strong requirements that they can't meet them and that they can't happen anyway. But besides that, can you make it real simple for us as the people who need some power, where does our power lie in the next step here?
I wish that everybody would hear me and take it to heart and act on it. The power comes from inside of you, nowhere else. If you don't do it, if you don't stand up, if you don't persuade your neighbor, there's a question in the chat here that is parallel to this. You know, how do we motivate community members who aren't here for meetings like this? That job is yours. You are here for this meeting. You're involved in this conversation. And if those folks who don't come to meetings and don't read about this, don't think about it, just let things happen because they have very busy lives. We all do. And we all wish we didn't have to deal with these things. And we all wish we didn't have to be the ones to step up and, you know, lose some sleep and maybe spend a few bucks to travel and talk to people. But if we don't take care of these things ourselves in our own communities, it's not going to happen. And they're going to go away, and our kids are going to be poisoned. And so will future generations. And Buckingham County is not going to look the same. And fewer people are going to want to live there. And its tax base is not going to be what it is now. Even if you don't think that it's as good as it could be, it's not going to be any better when you put a big hole in the ground and poison the water and the air and the soil. And so how do we motivate people? I wish I knew. I'm asking for you to take up this cause. And if you don't, I don't know the answer for you. We're the adults in the room right now. You know, when we're dead, then it's on our kids' shoulders and our grandkids' shoulders. And what are they going to think about us for not having taken a stand and got really, really serious about this? What will they say about us? I do wonder about that.
Thanks so much, Ben. Can I wrap it up? Yeah. So, any other questions?
Yeah.
Yeah, one more question. Short? Promise? Because we're going to get to the ice cream. Down the stairs.
What I would like to know is, what is the percentage of the gold mine toxification that we would endure to maintain good health here in Buckingham? Because we already have the slave quarry, we have the kinetic mines and some more things that I probably don't know about in Buckingham that might pollute the environment. So what does it look like if the gold mine is approved?
I'm going to let Heidi and Divya and Mindy and anyone else that would like to go ahead. You've been studying this for a while. Why don't you share a little bit about what you've found? What would the consequences be?
I think in the I'm going to take off my mask. In the interest of time, there's a lot to say about that. And there's a lot of information on the table outside that we can share with you afterwards. And I think that would be a lot more effective than talking about it, because we have some pretty descriptive maps and pictures that we can show you. And so I think since you're here, that would be the best way to answer that. Is that okay?
Fine.
Okay, great. So what we wanted to point out as a next step is the next time we call a community meeting, everybody, you all come again and bring a friend, and then we'll have twice as many people here. That's the first step. Bring a friend the next time. One other step that we can do is the next Board of Supervisors meeting is September 12th. We have to be there and we have to tell them what we've learned here today and how it impacts us. And they need to know that. They were all invited here today. They've been offered a private consultation with Ben to talk to him, roundtable, explain the ordinance. They have not accepted that offer. So the only avenue we have right now is to go to the Board of Supervisors during public comments, and only residents of Buckingham County. I'm not sure, we have some landowners here. I'm not sure about landowners. Can landowners come and make public comments? Okay, so you can come too. And so the only avenue for communication to get it on the record is to come during public comments. So put it on your calendars, 9/12, Monday, September 12th. We have to be there between 5:30 and 5:55 to sign up. And then public comments is right at the beginning of the meeting. So we can come, give our comment. We only have 3 minutes, so it's not a long time. So we suggest write it, practice it, and come and give it. If you need help, get in touch with us. We've written lots of 3-minute public comments that we can give you to say if you want. If you don't know how to language it or whatever, we can do it. We can help you. We can help you with that language. Just tell us what you want to talk about, and we can do that. We can do that with you. But it's really important. The next step is the September 12th meeting. You're welcome to write letters to your Board of Supervisors. And all of that, but that won't go on public comment. They have taken away our ability to zoom in. So we have somebody here from Texas who's a landowner here in Buckingham County. We have somebody here from Texas on Zoom. She can't give a public comment because she can't give a public comment on Zoom, and she can't write a letter. And she's a landowner here. You have to show up. So that's the bottom line. You have to show up and you have to give a public comment. So we're all here. So if you all come and they don't want a letter from us, they don't want an email from us. So let's have 100 people there, and they have to sit there and listen to everybody say, pass the ordinance. Now, don't wait for the state. That's the theme that we want to hit them with. You want to add anything?
I'd also like to add that we're not going to give up because we don't want this gold mine, right? So we don't necessarily expect to get what we want on the 12th. You know, when we started the Atlantic Coast Pipeline fight, they said it could be years and don't count on the courts. And it was 6 years. Now, I'm not at all, it's been 2 years now. I'm not hoping, I'm not wishing that on us at all, but when we quit is when we lose. And that's when we get the gold mine. So once a month, it ain't much, just show up and just keep speaking up. And if you get tired of it, pass it on, you know, tag your ed, pass it on to your neighbor, your friend. We got to pull this all together. Together we are stronger. Hanuman,
Yeah, could I just say that something you can do if your district supervisor that will run for the Board of Supervisors.
Yeah.
Thank you.
yes, we need true representation.
How about you?
We're big.
So how about you? So if we say that again. You have to be a resident, I think so, yeah.
Move on.
Yeah, move on up. I think the people that have property here and come from Charlottesville today to be here. So we applaud you. So are there any other questions for Ben before we say goodbye till the next time? And thank you profusely, Ben, for your
Someone
clarity.
at the back,
What?
someone at the back has a question.
Someone in the back.
I just wanted to sum up. It seems like what you're saying, can you hear me, Ben?
Yes, I can.
But we don't know if it's recording.
It seems like what you're saying is that we're fighting a battle really that started with the Constitution. When they opened doors for the wealthy to kind of have their way as they industrialized and took advantage of the country. And then it was furthered with Dillon's Law in 1860, where corporations were given, or the railroad in that case, was given precedence over landowners. And it's been multiplied many times by court rulings since then. So we're really fighting a battle that kind of was started at the very inception of the Constitution. And-
Well, it was. I'm sorry, did you have more?
No, go ahead.
Yeah, well, it certainly has to do with everything that was talked about in the Declaration of Independence. The very first grievance against the king meant, they mentioned like 30 some grievances at the end of the Declaration. We know the really inspiring language at the beginning, that, we hold these truths to be self-evident, all that stuff. But towards the end, they list a bunch of reasons why they're breaking from the British Empire. And the very first thing they say is that he, the king, as the kind of the representative of the empire, has refused our laws, which we need for our public good. What they meant was, by refusing the laws, the king, the empire refused local laws. Now, this is before the revolution. There were no states. So there weren't state laws that were being overturned. There was no nation. So there was no national laws being overturned. It was local community laws, mostly county laws, or laws passed by general assemblies or by direct democracy in New Hampshire and Vermont and other places, including New Jersey, where people could go to meetings, raise their hands, and vote on local laws. The very first grievance, the very first complaint against the British Empire, and the justification for saying we don't need you anymore, is that they were told, they didn't call it Dillon's rule then, Dillon hadn't been born, but essentially it was Dillon's rule. It was, unless the empire tells you that your local law is okay, it's not okay. That's the essence of Dillon's rule. It's also the essence of the rationale for the American Revolution. So let's stop having Dillon's rule shoved down our throats as though somehow it's the 11th commandment from heaven. It isn't. It's a protection for privileged property, for privileged wealth. And that's what large mining corporations own. It's a way to protect wealth against democracy. And maybe you're familiar with James Madison, who wrote the first draft of the US Constitution, said that they needed to create a document that would protect the minority of the opulent, the minority of the rich, against the majority, against democracy. And that's what we're looking at with these preemptive laws and this Dillon's rule invocation. Dillon's rule was not part of the Constitution. Dillon's rule wasn't even a national law. It was referred to in a footnote by the Supreme Court at the beginning of the 20th century and applied to all local governments. It isn't part of the American tradition. It's part of the tradition of destroying the right to self-government at the community level.
I think that's a good place to add.
Wow.
Yeah. Okay. Thanks so much, Ben, for your time and energy and with them. And I think, what's that? His book, you can talk about it.
Ben, could you just say a few words about your book, and at least the title?
Oh, well, I could probably hold up a copy if you want to see it, but it's,
Yeah.
if you want to understand some of this history, I kind of got into it here at the very end. The history of where these preemptions and Dillon's rule comes from, and the idea of protecting wealth against democracy. It's in a book that I wrote. It's called How Wealth Rules the World, Saving Our Communities and Freedoms from the Dictatorship of Property. And when I say property, I don't mean what you earn by working hard. I'm talking about wealth that is not earned, that's simply gathered, accumulated, and amassed, because it's used for the creation of governing power. And so, yeah, How Wealth Rules the World, Ben G. Price.
Okay, thank you. And if anybody wants to borrow, I have a copy of it. Anybody wants to
I
borrow?
suggest it because it would explain a lot of these things that, you wouldn't have to sit through a Zoom call. You could read it at your.
You wouldn't have to leave your comfort of your home. Okay, so we are, we thank you again, Ben, and for your time and energy. And we're going to go downstairs and have some ice cream. I'm sorry that we can't share that part of the meeting with you, Ben. Some ice cream and brownies and fruit. And it's all waiting downstairs, so you just have to go out this door, go to the right, and go down the steps. Chad's gonna lead the way, so that we can all talk to each other and get to know each other and share more than just listening, and share of ourselves and some fellowship too. Okay, so thank you all for coming. If you haven't signed the sign-in sheet outside, please do. And some of you asked, wanted to get some materials to take home with you, and we'll show you and answer your questions outside. Okay, thank you all so much for coming.